Hello and welcome to a new episode of Legal Wrangle on indirect taxes. Today we bring you decisions relating to reversal of Cenvat credit when the assessee's factory is partly sold, the condition of duty-free import of helicopter, availability of Cenvat credit of service taxes on servicing of windmills. Let's move on to our first case. The assessee is Hindustan Lever. An interesting question raised here was, when the assessee had sold its factory in a slump sale on as-is where-is basis along with the land, buildings, raw materials, was that a valid cause for reversal of Cenvat credit on inputs already claimed by the assessee? Will Rule 10 of the Cenvat Credit Rules 2004 apply? Let's go to Neha for the case details.
Sure, Manit. The assessee sold its manufacturing unit in a slump sale along with land, building, raw materials and semi-finished goods. The buyer too did not remove any inputs lying in the factory and continued with the manufacture, while being assessed under central excise. Revenue held that the factory was partly sold. Therefore, Rule 10, which permitted transfer of input stock and Cenvat credit to the buyer unit, was not applicable. Cenvat credit was reversed.
In the revenues appeal, the tribunal held in favour of the assessee, concluding that there is no condition prescribed under Rule 10 that it shall not be applicable in cases where the factory is partly sold. Let's move on to our next case. The assessee is Global Vectra Helicorp Ltd that had DGCA approval for importing aircraft for providing non-scheduled passenger services. The assessee had claimed exemption from duty on import of 2 helicopters previously on an undertaking given to the Deputy Commissioner Customs that these aircraft shall be used only for providing non-scheduled services, otherwise become liable for payment of duty. The question before the tribunal is related to the nature of services provided by the assessee and the availability of exemption. Neha has the case details for us.
Yes, Manit. A non-scheduled passenger service is defined with reference to Rule 3 of the Aircraft Rules 1937 as service for transportation of persons or things for remuneration by operating flights which must be open to the members of the public and must not operate as per the published schedule or timetable and or with regular and systematic flights. Sure, Manit. The assessee had a contract with several companies for transportation of their personnel and materials. But revenue noted that the assessee neither printed the passenger tickets nor were the flights open to the public. Revenue concluded that the assessee was offering charter services and not passenger services and raised a demand against the assessee for payment of duty on import of the 2 helicopters.
The tribunal held in favour of the assessee, concluding that there was no violation of import conditions specified in Notification Number 21 of 2007 as amended, which defined non-scheduled passenger services with reference to Rule 3 of the Aircraft Rules 1937. Let's look at the details of the decision.
The tribunal held offering the service to public at large includes entering into agreement for providing regular service to a few members of the public in regular basis over a period of time. The expression person includes the company under various tax laws. Printing of ticket is not an essential element and such a requirement is not there. Services provided by the importer are in the nature of non-scheduled passenger service. DGCA, being the appropriate licensing authority, is the best judge to decide as to whether the activity of the importer comes within the ambit of the license issued to the appellant by it.
The interesting question in our next case relates to refund of service tax. When the assessee had provided research and analysis services to its associate enterprise outside India which served customers in India, did it amount to export of service by the assessee for the purpose of service tax refund? The assessee is AMP Capital Advisors India, which provided management consultancy services to its associate enterprise, AMP Capital in Sydney, Australia, for which it received fee as remittance in convertible foreign exchange. Let's go to Neha for the facts of the case.
Yes, Mani. The assessee had provided advisory services to its AE relating to the investments and financial opportunities in India. Based on these inputs, the AE advised its customers located in India. The assessee claimed that as the AE was located outside India and the assessee had provided the services outside India, these services were covered under the export of services and thus sought refund in respect of input services under Rule 5 of the Cenvat Credit Rules 2004. Revenue rejected the refund of claims of the assessee, holding that the services provided to AE in Australia were actually used in India and therefore it did not qualify as export of services.
The matter reached the tribunal, which held in favour of the assessee, concluding that the services provided by the assessee were consumed by foreign AE for providing services to foreign companies and hence services were used outside India and amounted to export of services. Let's look at the details of the decision.
The tribunal held that the assessee has provided the services from India and the same was used outside India. Accordingly, it qualifies as export of services and refund is admissible.
In these days of power outages, our next case relates to windmill producing electricity. The question before the Bombay High Court was whether repair and maintenance services of such windmills is also an input service for availing Cenvat credit of service tax even though these windmills are located away from the factory. The assessee in this case is Endurance Technology that manufactures excisable goods like motor vehicle parts at its factory in Valuj, Aurangabad. The assessee had availed Cenvat credit of service tax paid on repairs and maintenance service of its windmill situated further away at Supa and Satara. Let's get the facts from Neha.
Sure, Manit. The revenue concluded that the Cenvat credit of the service tax availed by the assessee was inadmissible because windmills were situated far away from the factory premises. Proceedings for recovery of Cenvat were initiated against the assessee with interest. In appeal, the tribunal held in favour of the assessee that it was entitled to Cenvat credit.
The matter reached the Bombay High Court, which dismissed the revenue's appeal, holding that considering Rules 2, 3 and 4 of the Cenvat Credit Rules, it was clear that management, maintenance and repair of windmills installed by the respondents was input service as defined by Clause I of Rule 2. Let's look at the details of the decision.
High Court held Rule 3 and 4 provide that any input or capital goods received in the factory or any input service received by manufacturer of final product is susceptible to Cenvat credit. Rule does not say that input service received by the manufacturer must be received at the factory premises.
Our last case in this episode relates to value added tax. The question before the High Court of Delhi was whether higher charges received by the assessee from Delhi Transport Corporation to operate its buses amounted to deemed sales and transfer of right to use of goods to make the assessee liable for value added tax under Section 2 of the Delhi VAT Act. The assessee is Hari Durga Travels, a partnership firm registered as a tourist operator which provide vehicles on rental basis. It was registered for the value-add tax with authorities in Delhi. The assessee had agreements with Delhi Transport Corporation under which it provided deluxe buses with drivers to be deployed on DTC routes and received higher charges for DTC for running these buses. Neha has the details of this case involving a composite contract for goods and services.
Sure, Manit. Revenue treated the assessee's transaction with DTC as a deemed sale on account of transfer of right to use the goods and imposed VAT on the receipts shown by the assessee as higher charges. Interest and penalty were also imposed against the assessee. The tribunal too concluded against the assessee, holding that the DTC remained in control, supervision and possession of the buses except that these buses were hired or on lease. Hence, the contract had resulted in the transfer of the effective control and possession of the vehicles onto DTC.
The matter reached the Delhi High Court that held in favour of the assessee, holding that the custody and possession of the goods was with the assessee owner, who was responsible for keeping the buses fit for use through maintenance and repairs. Hence, the rights conferred under the contract on DTC did not result in the goods being delivered to DTC at any stage, and the contract did not pass the muster of Article 366(29)(a)(d) as held by the Apex Court in the case of Bharat Sanchar Nigam. Let's have the details of the decision.
High Court held registration and licenses are in favor of assessee. Assessee commits to be the bus owner at all times. Possession has always remained with the owner. DTC only plies the buses and has limited use for these buses. Rights conferred on DTC under the contract do not result in the goods being delivered to DTC at any stage. Contract does not pass the muster of Article 366, Subarticle 29(a)(d), so as to be treated as transfer of a right to use the goods or a demand sale transaction wrongly treated as sale of goods.
Well, this brings us to the end of this episode of Legal Wrangle on Indirect Tax. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to the TIOL Tube channel on YouTube. It's free and will keep you updated on our new posts. Have a good day.